begin early. That being said, we will hear from the appellant. I'm sorry. Case is State versus Tucker. We'll hear from the appellant.
May it please the court, my name is Bethany Bergen. I am here on behalf of the state of North Carolina. I would like to reserve 5 minutes for rebuttal at the conclusion of this argument, which I will be keeping track of. We are here on the state's petition for discretionary review that was allowed by this court. And the issue we are discussing today is domestic violence protective orders. And specifically what the issue we're looking at is, did the defendant have knowledge? Knowledge is the issue, knowledge of the domestic violence protective order. There's no question in this case whether there was a valid protective order, and there's no question about whether the defendant committed these acts of breaking and entering an assault with a deadly weapon. The question is, did he have knowledge of the valid protective order at the time he was committing these acts? Two motions to dismiss for lack of knowledge were made during the trial court's trial on this case. There was a motion to dismiss at the close of state's evidence made by the defense, claiming there was not knowledge of the valid protective order. The evidence of knowledge that the state presented during its case in chief, the main evidence was from this police body camera footage. What happened? The victim had an ex parte order and then had gotten a permanent order. And the defendant was outside of her door of her apartment, and she ran into the closet and she called 911. The defendant broke into her apartment through the window and assaulted her. The police arrived at the scene, and when the police arrived, they heard through the broken window the defendant saying, "I might as well kill you, I'm going to jail anyway." The police then entered the house and recorded on this body camera footage is the victim stating, "That is why I got a court order," and the defendant responding, "I know, I know." And that's in the record on the transcript on page 630. And in the transcript on page 707, it's again stated as the victim stating, "I got a protective order," and the defendant saying, "I know you did." The state also presented evidence that an ex parte order was entered. This ex parte order was based on the allegations that resulted in defendant's arrest and resulted in charges of assault against the defendant. The defendant was served with this order and told there would be an order on a permanent hearing where and when it would occur. And the state presented evidence that this valid permanent order was issued based on these same allegations from the ex parte order. The defense made a motion to dismiss at the close of the state's evidence, and the trial court judge denied that motion to dismiss. The defendant, during its case, presented 2 witnesses to testify on the defense's behalf. The first witness was the defendant's cousin, Charles Hinson. And he testified he knew the victim, he knew the defendant, he'd been to their apartment, he took them a housewarming present. And then he specifically testified that he, the defendant, was arrested for the protective order. He stated they told him not to go there and he went anyway or whatever. That much I do know, that he was arrested for doing that. And that's on in the transcript, page 721 through 722. Now, I will say, during that testimony, he said he was not clear whether this was about the ex parte order or the permanent order. So there's a discrepancy there that he did not firmly say this is about the protective order. This is about the permanent order. The defendant also presented Kent Matzinger, who was the assistant clerk of court in Mecklenburg County. They presented testimony of a hypothesis of innocence that the defendant was not served with the permanent order, therefore there was no way he could know about it. That's exculpatory evidence. The evidence favorable to the state that came out during this testimony was that if a defendant does not answer or appear for a hearing on a protective order, the court will often still proceed and enter orders for a victim, as was done in the case at hand. Orders are regularly granted when a defendant does not appear at a domestic violence protective order hearing. The court again, the defense again made the motion to dismiss at the conclusion of its evidence, and the trial court denied the motion to dismiss and sent this question of knowledge to the jury to make a decision. Court of Appeals reversed the convictions that were made based on the jury's decision at the trial court, and they said that there was not substantial evidence for the motion to dismiss to be denied. But in making this determination, the Court of Appeals viewed the evidence in the light most favorable to the defendant and used the exculpatory evidence presented by the defendant to accept the defense's hypothesis of innocence. Essentially, the court acted as the jury. The standard for a motion to dismiss is not beyond a reasonable doubt. That is the standard for the jury. The standard for a motion to dismiss is there substantial evidence? This court, and all the law I'll be quoting today is from this court. This is the standard coming from the Supreme Court of North Carolina. And this court has determined that substantial evidence can be deceptive because in the context of a motion to dismiss, it is interchangeable with more than a scintilla of evidence. The trial court must decide whether to grant a motion to dismiss based on whether the evidence considered in the light most favorable to the state is existing and real, not just seeming or imaginary. So for knowledge, knowledge may be proved by statements of the defendant, and it may also be proved with circumstantial evidence from which an inference of knowledge might reasonably be drawn, and that's the State v. Bogle case. Circumstantial evidence is sufficient to withstand a motion to dismiss, even if the evidence does not exclude every hypothesis of innocence. That's the State v. Stone's case, and what that is saying is that the state does not have to disprove the hypothesis of innocence in order to withstand a motion to dismiss. That is a question for the jury to decide. When carrying out this function, the trial court should be concerned with sufficiency alone, not with weighing the evidence, which again is for the jury to do. In making its determination, the trial court must consider all the evidence admitted, whether competent or incompetent, in the light most favorable to the state, giving the state the benefit of every reasonable inference and resolving contradictions in its favor. Contradictions and discrepancies do not warrant dismissal of the case and are for the jury to resolve. An exculpatory evidence presented by the defendant, unless favorable to the state, is not to be considered by the trial court when ruling on a motion to dismiss. So these are the standards set by this court, and I'll walk through this evidence again with those standards in mind. We have police body camera footage right after this act occurred with the victim stating, "I got a protective order," and the defendant stating, "I know you did." That is real and existing evidence. It is not imaginary or seeming. It's evidence that should be viewed in the light most favorable to the state. So if there's a contradiction or discrepancy with that, as does it apply to the ex parte order or does it apply to the permanent order, that is for the jury to resolve, not for the trial court judge. We also have this, and I'll be careful with my wording, we have an ex parte order that was issued to the defendant, again, based on the same actions he was arrested for and charged with. He knows of this hearing date. He does not show up for the hearing date, and these allegations go undisputed. The victim shows up for this court, for this permanent order. The defendant does not show up, and these allegations are undisputed. And that is circumstantial evidence to be considered by the court. Again, we have this statement from the defendant's cousin. The defendant's cousin was presented by the defense, but this is evidence that came out favorable to the state that's properly considered by the trial court judge when ruling on the motion to dismiss. And we have this inference, this assistant clerk of court saying these are regularly granted when defendants don't show up. And that is sufficient to send to the jury. The instruction to the jury from the trial court specifically covered this element of knowledge. So this was sent to the jury. That's in the record on page 58. The judge explains to the jury what they have to look at beyond a reasonable doubt to show knowledge of the violation of the domestic violence protective orders. And that was a question for the jury to resolve. I'm going to talk about a little bit now about the intent of 50B and how that should be looked at in making a determination for this case. And Chief Justice Newby, in your dissent in State v. Byrd, which I think is appropriate to discuss in front of this court, that case said it is appropriate for the court to look at the language of a statute to determine whether a contention has merit. And the courts of North Carolina have repetitively held that there is a clear legislative intent in Chapter 50B to deter violence and to protect victims. 50B should be read broadly and applied liberally in a way that protects victims of domestic violence. And what this Court of Appeals decision is doing in acting as the jury and holding, this is a higher standard that the Court of Appeals is holding for sufficiency of knowledge. It is not this beyond a reasonable doubt. It is sufficient evidence. And by holding the state to this higher standard, the court is stripping away this extra layer of protection that is intended by 50B. And that's intended with when the court says, we will go forward with this hearing whether the defendant is present or not. We will issue an order whether defendant is present or not. If the victim shows up for this hearing and testifies to these facts of abuse, we're going to go ahead and issue this order. We're not going to halt court and put out a warrant for arrest, get the defendant to the courthouse to defend himself, and resume the proceedings with the defendant there. The court would move forward with the protective order. So what this does here in this Court of Appeals opinion is raising that bar and stripping this extra layer of protection. And it's essentially creating this window Chief Justice Newby spoke about in the Byrd case. It's creating a window of opportunity for the defendant to disregard the enhanced sentencing created by the Domestic Violence Protective Order in this window before service and retaliate against the victim without accountability to the enhanced sentencing. And that is this enhanced sentencing and this accountability to deter domestic violence is the purpose of Chapter 50B.
Court of Appeals said in its opinion, I've just found it, it's on page 7 of the slip opinion, that, I'm quoting, quote, the state argued at trial that the second DVPO, Domestic Violence Protective Order, thank you, Senior Associate. now that my microphone is on.
I can hear you much better now. Thank you,
Okay,
Justice
thank you.
Morgan and Justice Hudson.
Yes,
Thank you, Chief.
yes, I apologize.
I don't have the best hearing, so I never know if it's me or the microphone, so thank you.
Thank you. With the microphone activated now, I'm quoting, I was looking in the Court of Appeals slip opinion. It's on page 7 where I'm quoting, quote, "The state argued at trial that the second DVPO was a continuation of the first," unquote. Are you agreeing with that statement?
That is not what I've argued before the Supreme Court today. I have argued that there is sufficient knowledge applying the standards of the Supreme Court. There was sufficient evidence of knowledge to withstand the motion to dismiss.
But as a premise, are you agreeing with what the Court of Appeals had said in its slip opinion, that there is an argument that was made at the trial level that the second domestic violence protective order was a continuation of the first?
The second domestic violence protection order is a separate order issued on a separate date. So the first order was from August 28th through the date of the hearing for the permanent order, which was the 6th of August. And on the 6th of August, the permanent domestic violence protective order was issued for a year duration.
Now, are you asking this court to establish that because there was an uncontested second domestic violence protective order opportunity, the longer term one, that with the defendant's failure to appear, that is to be deemed to be uncontroverted and therefore it would automatically be given?
No, I'm not asking the court to assume it's automatically given, but it's very likely, it's highly likely, almost to certainty, if the victim appears and the defendant does not, and the allegations from the ex parte order that resulted in an arrest and charges are testified to at the permanent hearing, it is extremely likely that order will be issued. And I am not asking the court to apply the willful blindness standard or to change what is meant by actual knowledge. What I'm asking the court to do is to apply the correct bar to hit for the standard to survive a motion to dismiss, and for the trial court not to act as the jury and not to require the standard of beyond a reasonable doubt.
So with the Court of Appeals saying that there was, and again, I'm looking at the slip opinion, still on page 7, quote, "The state presented no evidence that defendant received notice or was otherwise aware of the second DVPO," unquote. How would you look at, for our purposes, the strength of what the state is presenting today and emphasizing that was at trial, such as what the Court of Appeals said was tenuous in terms of the alleged victim saying, "That's why I got a court order," defendant replying, I know," the lack of the automatic availability of the determination that the alleged victim would get the DVPO. How does all that figure in terms of how you would say that you would want this court to look at the trial court's determination that the motion to dismiss should have been treated as it was?
So the evidence of the lack of service was presented during the defendant's case as exculpatory evidence that should not be considered during the motion to dismiss. It was presented for a hypothesis of innocence, and the state does not have to disprove that hypothesis in order to survive the motion to dismiss. Proof of service, if there is proof of service, the jury shall presume knowledge, but lack of service does not equate a presumption of no knowledge. And so when the defendant stated, I know you did, responding to the victim's statement that she got a protective order, that could be viewed as referring to the ex parte order or to the permanent order. And that is a question for the jury to decide.
On the question of the evidence, whether the evidence is sufficient, on whether the defendant had knowledge of the permanent order, is it relevant here that this assault happened the day after the hearing? And I suppose part of my question is, if, for example, this was 6 months after the permanent hearing and he'd never been served, wouldn't that be a different situation in terms of whether the evidence was sufficient on the question of his knowledge?
I know that the Court of Appeals has inferred knowledge of, in unpublished decisions, has inferred knowledge of renewed orders. I think here, in this case, there's evidence that this cousin, the defendant's cousin, Charles Hinson, knew the defendant, knew the victim, was familiar with both of them, had been to the house several times. The defendant's sister has given a TV to the victim. These people know each other. This is what happens with these cases. The defendant doesn't show up for the hearing, and everyone is talking about it. I think that these first few days after an act of domestic violence into the first few weeks are the most vulnerable point for this victim. And that is when the victim should truly be protected, because this is the point where the abuser can get back into the victim's life and continue on this cycle of domestic violence. And I'm not sure that answered your question, and maybe I might not be understanding it completely.
Yeah, I apologize. It was not very well worded. Apart from the question of needing protection and the importance of this period of time, just on the more narrow question of what evidence should we take into account when we're figuring out whether or not the evidence was sufficient on the question of the defendant's knowledge. I just wondered whether the state's position is that the fact this assault occurred the day after the hearing is relevant information that would be available to the jury to consider, tending to show that when he said, I know, he had knowledge of the permanent order.
That's correct, Your Honor. I think the instruction was given to the jury. The jury knew the dates of these orders. They knew it was the afternoon of the 6th was the permanent hearing. He came the morning of the 7th. Not even 24 hours in between. Again, she said, this is why I got the protective order, and he stated, I know that you did. And I think you have to view that in the light most favorable to the state and allow the jury to resolve the discrepancies or contradictions.
And counsel, that's my question. Following up on what Justice Morgan asked, on page 9 of the slip opinion, the Court of Appeals indicates that because any circumstantial evidence of his knowledge was, quote, tenuous at best. Is the description tenuous at best? Do you think that's most favorable to the state? And even if it's tenuous, is that evidence more than a scintilla of evidence?
I believe it's more than a scintilla, and the evidence, the defendant stated, I know, in response to, this is why I got a protective order. I don't categorize that as tenuous evidence. I believe that is more than a scintilla of evidence. Then it is to be viewed in the light most favorable to the state, and the question goes to the jury to weigh the sufficiency of that evidence. The trial court is not to weigh the sufficiency, it's to send to the jury to weigh, and it's sent to the jury to resolve any discrepancies or contradictions. Any other questions right now? All right, I am going to go ahead and reserve my 5 minutes for rebuttal. Thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court, my name is Guy Larange, and I'm here today on behalf of the defendant appellee, Mr. Mitchell Andrew Tucker. Mr. Tucker has been incarcerated since September 7th, 2017, based on the charges of this case that we're discussing today. The main issue in this case is, did the Court of Appeals err by holding that the state failed to present sufficient evidence that Mr. Tucker knowingly violated the September 6th, 2017 Domestic Violence Protective Order? I'd like to start by looking at the statute that lies at the heart of this case, and that's 50B-4.1. Under subsection A, it's a Class A1 misdemeanor if a defendant knowingly violates a valid domestic violence protective order. Under Section G, it becomes a Class H felony if the defendant does so while possessing a deadly weapon. In 50B-4.1, the term, in some form or fashion, knowingly violates valid protective order is used 8 times. And I think from there we can see the General Assembly's intent is clear, is that for a defendant to be convicted of violating this statute, if to be convicted at all, the state needs to prove that there was a valid protective order in effect, and that that was the order that the defendant allegedly knowingly violated. In this case, Mr. Tucker was indicted for a violation of 50B-4.1G. The indictment in this case specifically alleged that Mr. Tucker knowingly violated this September 6th, 2017 protective order that was entered in Mecklenburg County District Court. The state, in its arguments, in its briefs, has asserted that whether when Mr. Tucker said, I know, in response to Ms. Pascarella's statement that she had gotten a protective order, he could have been referring to the protective order that was entered on August 28th. He could have been referring to the protective order that was entered on September 6, 2017, or both. And that's not what the law says. The law says if you are to be convicted, if convicted at all, it is based on the particular offense charged in the indictment. And here the particular offense was that Mr. Tucker violated the September 6, 2007 Domestic Violence Protective Order. In that indictment, the date is not surplusage.
Just to make sure I'm following you, Mr. Larange,
I'm sorry.
Are you arguing that the state's contention now is that a showing that the defendant was aware of the ex parte order is sufficient? I didn't get that argument from your colleague, and I just want to make sure that
It was an argument raised that his I know, it was just a point raised in the state's brief that I know could have referred to one or other or both. Was the statement.
I had understood her point, and maybe if I've got her point wrong, she can correct me. Hope she will. That admittedly, it's not definitively stated in the record which order was being referred to in the I know statement, but that it would be reasonable to infer that we were talking about the permanent order. I mean, that seemed, I understood that to be her argument. Do you understand it differently?
It was a argument made by the state, and it's.
Right. So the real issue
I believe
that
it
we've
was
got,
the reply brief.
So the real issue that we've got to resolve is whether her assertion that it would be reasonable to infer that the defendant was referring to the permanent order. Is that a reasonable inference or not? That's one of the questions we've got to decide here.
Well, that's the key question that we have to decide is whether, based upon the state's evidence, a reasonable inference could be drawn that Mr. Tucker knew of the protective order, and then from that we can reasonably infer that he knowingly violated the order. That's the essential fact that's in context.
That's what I thought really what it got down to. So why, in your view, I've heard her argument as to why it's reasonable to assume that we're talking about the permanent order. Why is it your view that it's not reasonable to make that inference?
It would not be reasonable because when you look at the record, and as the Court of Appeals did, when you look at the record, we have, we can conclude from this record, from the state's evidence, that Mr. Tucker was aware of the 8/28/17 domestic violence protective order. He was, the state's evidence, which is state's exhibit number 2, this is the state's evidence, not Mr. Tucker's evidence, shows that he was served with a copy of that order, that he it was actually read to him at the jail by a sheriff's office employee on 8/28/17. So you can conclude, reasonably infer from that, that he knew that that one existed. He also received a notice that said that he would need to appear for the September 6, 2017 hearing, and at that hearing, the court would determine whether an order will be continued. That notice did not say if you do not appear or that an order automatically will be entered on this date, on 9/6/17. He's also provided with a summons that said that if you fail to answer this complaint, the plaintiff will apply to the court for the relief demanded in the complaint. But in neither case does it say that that if you don't go, if you don't answer the complaint, that a new order will be entered on September 6, 2017. So therefore, when we look at his I know statement, we have to look at the fact that the only thing he had actual notice of was the 8/28/17 domestic violence protective order. The state,
Or the only thing that we have documentary proof that he knew about.
yes, because if you look at state's exhibit, exactly, because if you look at state's exhibit number 2, there's nothing in there that shows that he ever received a copy of the September 6, 2017 domestic violence protective order. So you can't, I think, reasonably infer, reasonably infer that he was referring to an order that had never been served on him, that he was referring to that order. And I think that's even viewing the evidence in light of favorable
Just to make sure I'm understanding your argument, Mr. Naranja, is your contention then that in the absence of direct evidence of service on the order or direct evidence that someone told him about the order, there's insufficient evidence of knowledge?
Well, I think it's an important,
it's clearly relevant whether that's true or not true, but is it your argument that it's definitive?
well, you have to look at the circumstances, and I think that's an important circumstance. The 50B-2 requires this summons, requires it to be served on requires it to be served on the defendant in these cases. Could you just repeat your question one more time? Sorry, I lost my train.
I get that this would be a relatively easy case if we had a return of service that showed that the permanent order had been served on your client. Or if there was a witness who came up and testified, yes, I saw your client and I told him that this order had been entered. That would be a pretty easy case, I think, on the issue of knowledge. We don't have that here. Is it your argument that in the absence of such evidence, a jury is not entitled ever to find the existence of the requisite knowledge?
No, that's not my contention. My contention is that in the absence of actual notice, you have to look at if there's any other notice from which it could be reasonably inferred that Mr. Tucker had notice of this September 6, 2007 protective order. Once again, I think him saying, I know, in the context of actually never having received it, though, then that evidence I don't think carries much weight, or that statement doesn't carry much weight. I know. If he never had he never had been served with this September 6, 2017 order. I also think that in the Court of Appeals did point to 2 unpublished opinions. And I know
Before you leave that.
I'm sorry.
That's fine. What's your position on what the state offers as the proverbial other side of the coin, which is that the defendant's statement, I know, in response to the alleged victim saying, that's why I got a court order, could be construed as his acknowledgement that he is aware of a second order and that her statement, that's why I got a court order, relates to a second order. Said another way, in terms of postulating it that way, couldn't those statements go to a second order just as they could the first order, in terms of therefore saying, let a jury decide?
Well, I think you have to look at the fact, in Justice Earls, you mentioned this, that, and I think it is relevant, that within this order, or he showed up to Ms. Pasquarello's apartment less than 24 hours after this order had been entered. And I think to say that his statement, I know, would refer to an order that had been in effect less than 24 hours, that there was no proof that it had ever been served on him, to say, I know, I think that's, the state is entitled to every reasonable inference, right, from the evidence, every reasonable inference. And to say that his I know was referring to an order of which he was never served, I think that's not a reasonable inference. And to get to Justice Burr's point, I think you mentioned that, well, to say that it's tenuous, well, that at least meets the minimum of sufficiency. But I think, once again, it doesn't meet that minimal sufficiency. If you can't reasonably infer that that statement was referring to the September 6th domestic violence protective order.
Well, the Court of Appeals said there was no evidence, not that there was not reasonable evidence, but that there was no evidence. How would you respond to that in the context of there was a sufficiency of the evidence, again, just parroting what the state has said in its argument, enough to go to the jury, as opposed to the Court of Appeals determination that the motion to dismiss should have been allowed by the trial court?
Sorry, could you repeat it just slightly again?
I'll try.
I'm sorry, I apologize.
No, that's fine. In terms of what the Court of Appeals has said, the Court of Appeals has said defense motion to dismiss should have been allowed.
Yes.
In light of what the state is saying, which is that that the Court of Appeals erred by saying there was no evidence, and what I believe I just heard you say, that there was not a reasonable inference that could be said existed, what would be your response then to what the Court of Appeals said, which was there was no evidence, in light of what the state is saying, that there was enough evidence at least to go to the jury?
Well, once again, no actual notice in the record and no evidence from which you could find that there was constructive notice that Mr. Tucker knew of that domestic violence protective order. The state is saying that, I guess, that I know is part of the circumstantial evidence that leads us to infer that he knew the order existed and therefore knowingly violated it. And you can't rely on that I know statement, because that statement, I think you're going back to, it's speculation, it's conjecture. To say that, to say that it was referring to the September 6th one. So therefore, it is no evidence. It's not evidence that can be relied on to withstand a motion to dismiss there's just no reasonable inference that could be drawn from that evidence that he was referring to the one that he was indicted for violating.
So let me ask you about the reasonable inferences just a little bit. You would agree, I assume, that it's reasonable to infer from the service of notice on the defendant of the hearing that he knew there was a hearing to be held on September 6th.
Yes.
And that at the hearing, something was supposed to happen about whether there was going to be a new order. Reasonable to infer that?
Yes.
And reasonable to infer that he didn't show up.
He didn't show up. The record is silent as to why he did not show up.
But it's reasonable to infer that the defendant knew he hadn't been there.
Yes.
And so that whatever happened would have happened without his input.
Without his input, yeah, it would have happened without his input. But I think the summons in the notice both state that the plaintiff will comply for relief, that the court, I believe, will determine whether an order will be entered on that date. And so...
But it's reasonable to infer from the notice that,
that
it was a possibility or a likelihood that an order would be entered that day.
I think likely, though, is speculation. I believe you're basically saying, well, we're pretty sure it's going to be entered on this day, so he had to have known that it was entered because...
Or an order saying something.
there might not have been any order entered on the date. I mean, there was no evidence that, I mean, the state says that Matzinger, the assistant clerk, said that orders are routinely granted when the defendant isn't there for the domestic violence protective order hearing. But he also said that they're also routinely not granted. I mean, that you don't know. You're basing it on conjecture. And when you're going to sentence a man for 95 months, such as Mr. Tucker, it should be based on more than conjecture and speculation. It should be based on facts from which reasonable inferences could be made.
Well, if you have testimony that they're routinely granted, on the one hand, and also testimony that they're routinely not granted, the jury could believe whichever they want, couldn't they?
The jury, based upon that, it's just that, what is the jury supposed to conclude? The jury then from that can conclude that sometimes they are and sometimes they're not. The jury can't conclude that because he received notice in summons, or notice in the summons, that this hearing would take place, that he knew that the order was entered on that date, and therefore he knowingly violated that order when he went to Ms. Pascarola's apartment on that morning.
Well, isn't it well established that the jury can believe some, all, or none of testimony?
Sure, yeah, sure, but the jury can't, I don't think the jury should be making a guess as to whether he knew the order existed. I don't think that's sufficient to withstand a motion to dismiss, to submit something on conjecture and speculation. And that's what the Court of Appeals found. And primarily, I think that's why the Court of Appeals rejected the state's argument that the I know statement could have referred to the second domestic violence protective order, because it's based on speculation. It's too tenuous. You're basing it on, an inference that he understands civil law, or civil procedure. So I feel like it's too much of an inference to make.
Counsel, Justice Morgan asked you, and he stated that the Court of Appeals opinion indicates there was no evidence, but then separately says that the circumstantial evidence was tenuous. Are those two statements congruent, incongruent?
Yes, because substantial evidence is evidence which, from which a reasonable, substantial evidence, the definition of substantial evidence is evidence from which a juror can rationally conclude that a fact exists. And to say it's too tenuous or to say there's no evidence, I believe it's pretty much the same thing, because too tenuous means that there's no reasonable inference can be made, and to say no evidence means that there is no evidence from which a reasonable inference could be made. That's what I believe the court was getting at, was just saying that you can't say that his I know statement was referring to the second DVPO when he never received service of it. There was no proof anywhere that he had actual service or actual notice of it, and it's too speculative, and therefore it's not evidence. It's just speculation at that point. I'd like to just clarify a couple points, and that is that the state has made the point that the Court of Appeals considered Mr. Tucker's exculpatory evidence. That is not true. The Court of Appeals based its opinion entirely on the state's evidence, and specifically on state's exhibit number 2. And the court found that state's evidence simply did not establish that Mr. Tucker received notice of the September 6th domestic violence protective order. Second, I would also like to discuss the state's point of whether this Court of Appeals decision will lead to, I believe the state called it the absurd result of placing a higher burden on the state. While service of the domestic violence protective order in this case was important, having some evidence that he was served with this 9617 order and therefore he knew it existed and therefore he knowingly violated it, there can be circumstances where a defendant could be found guilty of knowingly violating a protective order without proof that he was served with the actual order, or without proof that he went to the hearing. And the Court of Appeals did look at 2 unpublished opinions and did point to circumstances in those opinions where it could be reasonably inferred that the defendant knowingly violated the protective order without proof of service of the order, or without him having attended the hearing. For instance, the order could have been in place for an extended period. He could have gone to a previous hearing or a renewal hearing, or he could have made statements that, in the context, in the circumstances, indicated his knowledge. But here, we had a protective order that was in place for less than 24 hours. It was served at a place, the jail, where he no longer resided, and the September 6, 17 order was a separate order. It was not a renewal or a continuation. It was an entirely separate order. And so I think there could be circumstances where the state could show that a defendant knowingly violated a protective order, even without proof of service of the protective order or him having attended that specific hearing. But in this case, those circumstances simply didn't exist. The other thing I'd like to discuss is the state said that this will create a loophole for abusers to escape punishment. And I just want to once again point out that there's no evidence in this record that Mr. Tucker ever intentionally avoided the September 6, 2017 hearing. The record is silent as to why he did not attend. And also, I think if he was not present at the hearing or served with the domestic violence protective order, once again, the state could still prove circumstantial evidence showing that he knew of the order. But also, I think if he avoided service, then to me that would be evidence of knowledge of the domestic violence protective order, and therefore that would be knowledge that he knowingly violated the order. I think the state, I think, is really, just kind of making too much out of that, to be quite honest. I don't think it's going to create a loophole. I just think the state needs to present sufficient evidence to establish that a defendant knowingly violated the order. And there are other ways to serve it, to meet that without evidence of service of the protective order or that the defendant attended the hearing where the order was entered. The state also made in its reply brief, made a statement that this court, that 50B should be read broadly in favor of protecting domestic violence victims rather than narrowly in favor of defendants in a way that allows them to evade punishment. The state did base this on Chief Justice Newby's dissent in the Byrd case, where Chief Justice Newby said that 50B should be construed liberally in the interest of deterring domestic violence through enhanced sentences. But I'll just point out the Byrd case, I believe, is a very different issue. Byrd was whether a temporary restraining order, whether a violation of a temporary restraining order that was entered under Rule 65B was the equivalent of a protective order under 50B, and thus whether the defendant could face enhanced punishment under that statute. It did not deal with whether the defendant knowingly violated a 50B order. More importantly, I think the state's rule, or the state's position, would go against the rule of lenity, which forbids a court to interpret a statute so as to increase the penalty it places on an individual when the legislator has not clearly stated such an intention. So I believe that I would ask this court to reject that position by the state. Additionally, I think there's a question is, for what relief is Mr. Tucker allowed to receive due to the errors below? And based on a knowing violation of, because a knowing violation of valid domestic violence protective order was an essential element of both felonies for which he was convicted, those convictions should be reversed, and because his habitual felon plea was based on the, there's no felony upon which to base his habitual felon plea, that should be vacated as well. The last point I'd like to make is that the state sought discretionary review and is arguing in its briefs that the Court of Appeals viewed the evidence in the light most favorable to the state because the Court of Appeals found that Mr. Tucker's I know statement could have referred to, or could only have referred to the 828-17 domestic violence protective order. And the Court of Appeals, I don't believe that's exactly what the Court of Appeals found, and during the state's rebuttal time, it would be nice to know what part in the opinion the Court of Appeals says that the I know statement could have referred to the 828.17 statement. That's not what the Court of Appeals said. The Court of Appeals just said that based on the evidence in this case, the state's evidence, you could only reasonably infer from this evidence that Mr. Tucker was aware of the 828.17 order. This court just rejected the state's argument that I know could refer to the 9617. But the court did not say that I know could have referred to the 828.17 argument. That was not the Court of Appeals' opinion. That's not what it says. And so I think that's important just to make sure that we understand what the Court of Appeals said in its decision. My final request would be just for the court to consider dismissing the state's petition for discretionary review as improvidently allowed. And I would take any more questions if you have any more, and if not, then,
Thank you, counsel.
all right, thank you.
Rebuttal.
Defendant spoke to you about some unpublished cases from the Court of Appeals where the Court of Appeals inferred knowledge. The Court of Appeals chose not to follow those cases for whatever reason in this case, but I think it's highly important for this court to think about the fact that this is a published opinion. This will have precedential impact not only on Deanna Pascarella and the rights she should be afforded in the case at hand, but it will have a precedential impact moving forward in general to victims of domestic violence. And what this opinion is essentially saying is that the state needs to show proof of evidence, and that proof of service to show knowledge. And that is contrary to what this court has set as the standard. The state may use circumstantial evidence for a reasonable inference of knowledge. This opinion from the Court of Appeals almost completely discounts circumstantial evidence. To respond to what was stated about Byrd, the Byrd case had one issue about this Rule 65 protective order versus a Rule 50B protective order. But what also happened in that case was that there was an ex parte 50B order, and there was going to be a hearing on the 50B permanent order. The defendant retained counsel, continued the hearing for that permanent order, and instead went and shot his wife in the head on that day. In that case, what came up from was the problem that the defendant hadn't had the right to be heard. Therefore, he should not have enhanced accountability for shooting his wife. That has received a legislative fix. We do not need a legislative fix today to give Ms. Pascarella the protection she should be afforded. What we need to do, what the court needs to do, is apply this standard at the level for a motion to dismiss. Don't set the bar so high. This is a question for the jury. The trial court correctly determined the question should go to the jury, correctly instructed the jury on knowledge of violation of a domestic violence protective order, and the jury did its civic duty. This is what our nation does. We have jury trials. We have since the beginning. You have a right to a trial from 12 of your peers on a jury. So what I'm asking this court to do today is to reverse the Court of Appeals opinion and uphold the decision made by the jury at the trial court. Apply the standards that the Supreme Court of North Carolina has set to find sufficient evidence for this motion to dismiss. Any questions?
Thank you, counsel.
Thank you.
Thank you to both counsel. Madam Clerk.
Excellent job to you.